Good morning, everyone. Welcome to Contemporary Issues Sunday School class. We are glad to have you today. And our own personal attorney is here to answer any questions that you have about legal issues. But he's retired. He just said, not really. Not really open to answering.
No, strong arm.
Yeah, that's right. If you've had any accidents lately that you'd like to, feel free to talk to Jim. Well,
It's
before
those
we,
99% of the bad lawyers that ruin it for the rest of us.
is it most of the, yes,
It's a joke.
it's like anything else. Before we do that, welcome to our Zoomers. Please mute yourself in the lower left corner of your screen, and we are recording this for future playback. And any other announcements? July or August 31st
Right.
is our summer party at the Punings house. Yes, so come for food and fellowship if you are free, and bring food. Yes. In the backyard. He's not cooking everything. Okay. Very good. Any other announcements? Thanks. No, let's get right into the Constitution. And welcome Jeff Klaus, longtime St. Andrew member and teacher of different classes here and retired attorney. And coming up, chair of the church council. St. Andrews, so like the president of our council governing party here. Yes, have any questions about the church? You can approach Jeff.
Later. I'm not the president now, or
Does he take over for Jesus? Oh.
it's Allison.
Allison is currently the president.
Oh,
He'll be taking over. But a Renaissance man of many hobbies also. He just told me he was taking up archery in his retirement, and he's just bought a Dollar General store in Moffett, Colorado. Yes, that has different investments. So Jeff's a man of many colors. And with that, Jeff talked to us last time in part one of this about what the Constitution is and some of the challenges to it. And so we got into it so well and so many questions, we decided to have another session because there's a lot going on every week. There's a challenge for the Constitution and questions about the Supreme Court and the law. And we thought it would be a great advantage to have Jeff tell us more about it. So with that, please welcome Jeff.
Oh, thank you, Steve, and thank you all for letting me come back. Again, I'm Jeff Klaus, and I am a emphasis on the first word, retired lawyer, and no longer practicing. And my disclaimer, as always, is that I'm not an expert on the Constitution per se. I'm kind of an armchair scholar, if you will. I like to think that I'm pretty well informed about it and do have, the legal education behind reading cases and analyzing cases and the Constitution. But I'm certainly not the last word. I am glad to be back because we really just barely touched on things last time. If you were here last time, you remember we did talk about some of the purpose, structure, and function of the Constitution and what it is, our founding document, as well as the substantive law of the land. We then got into the First Amendment and did talk quite a bit about the First Amendment and what all it is, and maybe how that relates to Christian nationalism and some of those movements that we read about so much now. But we didn't get into some of the other things that I wanted to talk about. And we did talk about interpretation, and I wanted to touch on that again because it keeps coming back up. This particular Supreme Court we have is the first one that is really dominated by jurists that have the textualist, originalist philosophy, that they try to read the words of the Constitution the way they were written at the time and kind of disregard some of the other more traditional interpretive tools that Supreme Court justices have used since the very first Supreme Court, in Marbury versus Madison and the early court opinions after that. Some of those other interpretive tools include the history, legislative intent, what a fictional reasonable legislator might have, and those have a goal of interpreting the Constitution and other statutes based on what their purpose is, what the consequences of the interpretation are, and their workability. Whereas textualists tend to want to ignore purpose, consequences, and workability. They argue that those factors can be misused by judges that are so-called activist judges to impose what they think is good and what they think a good purpose would be, as opposed to what the words meant at the time the Constitution was enacted. And so we're seeing some kind of different outcomes based on that. The recent book by Stephen Breyer, former Supreme Court judge, he has speculated that we may be going through a paradigm shift in the way the court interprets the Constitution. And it's happened before, back at the turn of the, into the 20th century. There was the Lochner courts, very conservative, very laissez-faire. And those courts interpreted the Constitution a certain way and very limited in what they would do, very limited what they'd allow Congress to do. Then we had like the New Deal court that allowed dramatic changes and allowed us to implement labor laws and wage and hour laws and all kinds of employment safety laws and other things that helped implement the New Deal. Then we transitioned into the Warren Court, which got even very different and kind of blended into the Burger Court, which had a lot of social policies and went very forward. That's where we got Roe v. Wade. Now we're possibly in a new paradigm with the textualisms, where we're going to have more cases like Citizens United, more cases like Dobbs, and other cases with very important issues coming up. So, and maybe more deference in these cases to the executive, like we've seen in these cases. One of the things I sort of talked about is impoundments last week or last time. We didn't really get into it. And it's been kind of overshadowed by other issues. I don't know if anyone has any interest in that, but that's kind of where the executive just keeps money that's been allocated by Congress and doesn't spend it. And that got kind of overshadowed by DOGE, where we ended up kind of terminating all the people that would have spent it anyway. And the Supreme Court hasn't enacted or spoke out on that yet and made a ruling. But a number of lower courts have ruled about various funds and grants, saying, one way or the other, that they can't be withheld or they can be withheld, and that's yet to be decided. But it seems to me that there's the big issue is that Congress isn't fighting back on that and protecting its own turf. Normally Congress would say, that's our bailiwick, that's our turf, you stay off of it, and we get to decide that. And what we've got now is a Congress that's kind of going along with that and ratifying cuts, not only in current legislation, but just by its own inactivity. It's not asserting its own sphere of influence in we have the separation of powers that we have. So that'll have to still play its way out, but all of that has kind of blurred the lines between separation of power that the Constitution was meant to preserve, and weakens Congress and strengthens the executive. So I think that's going to be a long drawn out process. One of the big issues, just to change gears, and if you have a question about anything as we go along, especially if it's something I'm talking about right now, just raise your hand and question.
You mentioned that the Supreme Court is more of a textualist, right? That they go to the actual Constitution. But my observation of some of their rulings is that they only use it when it's to their advantage, because Citizens United, there were no corporations or anything in the early time of Constitution. So how did they then come to the belief that corporations should be people?
Well, actually, corporations have been around for quite a long time, and not in their current form, but the fictional purpose for carrying on business has existed since the time of the Constitution. But I mean, certainly it's evolved quite a bit since then, but the common law related to corporations has always recognized that those have been granted sort of personhood for conducting business, owning property, entering into contracts, and all of that kind of thing. So that piece of the puzzle wasn't really that big of a surprise to me, and I don't think to a lot of lawyers that the Supreme Court would say that a corporation is a person. But then where you get, I think, the textualist and originalist twist to it is where they'll then say that extends to a right in the Constitution, in the First Amendment in particular, free speech. I've said I think that the donating money is not necessarily speech either. It's just kind of a megaphone. It's an amplifier of speech, not really the speech itself. And so there could have been a lot of ways that they ruled on that differently without, eroding or getting into the idea that a corporation has certain attributes of a person. But good question. Yeah, that's a problem case.
How often do you, sorry, Bill, I'll go ahead and then I'll come right to you.
No problem.
Jeff, how often do you think Supreme Court judges make decisions more influenced by their own ideology than their own belief in what the Constitution says? Do you think they're often?
Well, I think they are more often than they think themselves. I think all the judges, I think, are giving some effort to trying to be an unbiased analyst and scholar of what the law says. So I think, they would all claim that they're following a methodology that is neutral. And that they are not biased. And it certainly doesn't ever seem that way to a lot of us just looking at the decisions. And I think like the Dobbs case, for example, seems definitely that it was outcome oriented. That, they looked at all of the law and all of the history in a way that would lead to the conclusion that they wanted to reach.
But getting to Steve's question, what about the judges who are receiving gifts from certain vested interests?
What do you think? That seems pretty obvious. I mean, yeah, no one receives gifts. I mean, that's one of the oldest sales techniques in the world, is to send you a free gift and make you feel obligated then to want to buy something from that company or donate money or it's hard to imagine that doesn't influence them at some level. They're probably consciously saying, oh, no, that doesn't influence my opinion. But, there's one justice on the Supreme Court, for example, that comes to mind with that's been flagrant. And, that's a good Supreme Court question. There's nothing in the Constitution that really addresses that. And the Supreme Court itself has really refused to adopt a robust ethics policy and enforce it. All of those things, in my opinion, erode all of our confidence in the judicial system of some amount, because you believe that those people are going to favor the people that gave them gifts. And
Right. Bill had a question.
When I say this, and I understood this carefully, I don't want what I say to short circuit anything where you're going, because I recognize this is about the US Constitution. But you may already have this in your presentation, but at some point, maybe as we go through, I'd like to see, are there other, every country's different history, everything, other, what we used to call a democracy, even though we're a republic, that how they have managed, some situations, but I don't want you to, I'm not asking you to.
You are.
No, I'm not asking you to dive into it now, I'm saying.
No, I was gonna say, Bill, you're suggesting part 3 to the Constitution where we do comparative, Constitution.
That'd be great.
Yeah, no, I don't really have anything in my comments today to compare our Constitution
Forget that.
to other countries, but there are quite a number of countries that have constitutions or other enactments that address some of the very problems that we're talking about now. For example, with the Supreme Court, we could look even at state constitutions to see how they do things differently than our US Constitution. Most of the state constitutions, to some degree or another, are modeled on the US federal Constitution, but almost every state has either age limits or term limits for their Supreme Court justice. They can't stay on there forever and they age out. Colorado is an example.
Well, it sounds like you've got a part 3.
Yeah, no, that's a great idea.
I mean, if you're planning to do a part 2. I don't want to short circuit where you're going, so. Sorry.
Yeah, no, thank you for that. Our Constitution's so hard to change that even having those other models right in our face doesn't make them as useful as you might think, because, it takes acts of Congress and ratification by all the states to change the Constitution, and that would be very difficult right now to change even the most innocuous thing that seemingly everyone should agree on. So even like that's a kind of a segue to an idea or a thought that I wanted to just hit on with interpretation, and we'll move on after that. I did talk about impoundments already, but the "we the people" phrase, it's not even in the body of the Constitution, but the preamble, first words. There was recently a paper written by a student at a law school as part of some legal. Yes, people have seen it in the news. And it makes the case that the word "people" under a textualist interpretation really meant the land-owning white males at the time.
Yeah.
And he makes a strong case for that, I guess, as strong as you could, based on that textualist viewpoint. And he won some kind of award from his law school or from the contest for this article that basically calls for white Americans to take back the power of the country and reassert that. Now, there's other uses of words persons in the Constitution, and he didn't analyze that. Like the word person is in there, it includes free persons and non-free persons. So I would equate the word persons with people. So I'm not sure that analysis is without a lot of flaws, but you can see where you might go with that. And the place where I would hate to see it go is someone that finds that paper compelling would then go to the issue of birthright citizenship.
Right.
Where it clearly was enacted, the purpose of the 14th Amendment was post-Civil War to abolish slavery and to make it clear that former slaves had all the rights of any white citizen and so forth like that. But you could then get very limited in that interpretation. At the time the 14th Amendment was enacted, it did not, those rights didn't include women.
Right.
They didn't earn suffrage until much later. So, the 14th Amendment had some narrowness to it at that time. But, you know, the birthright citizenship is, to me, one of the most troubling issues that's come up, one of the most troubling executive orders that Trump has put out. And if you read the executive order, it really sounds kind of awful. And I think one of the exceptions in the executive order also includes what they call the kind of the Trump exception, where it excludes people that were born in the US, even if the mother was unlawfully present, if the father was a United States citizen. And so that kind of gets his kids in around that. But so I mean, it's not. So I think a real tragedy would be if that got interpreted the way Trump wants to do it, to make all of these people that have been born in the United States, have lived in the United States all of these years, and now make them non-citizens and subject to deportation and all kinds of other hardships. I don't think, okay, first of all, I wanted to mention you, there's been a big case that was in the news for a while, Trump versus CASA, and it was on the birthright citizenship cases, but it does not decide birthright citizenship issue. It does not decide whether that executive order is constitutional or not, or whether it violates the 14th Amendment. It's kind of a jurisdictional case. And a lot of the Supreme Court cases get decided on jurisdictional issues. In fact, federal jurisdiction was a whole law school class that we took just to learn what cases had federal jurisdiction, what were the standing requirements, what's the venue requirement. And in that case, the court was only ruling on what the federal court judge's ability to issue what are called universal injunctions. And you've probably heard that word. And the Supreme Court said that if a federal court does not have authority to issue a universal injunction, and that basically just means that their injunction can only apply to the plaintiffs in that case. So the parties that were seeking relief, and they can't apply the injunction to other people that have not yet sued. And in the meantime, there's been another case, and a federal judge did grant another universal injunction, but the distinction there is that case involved a class action. And so the purported class in that case encompasses a more nationwide scope, and that hasn't been brought up to the Supreme Court yet, but that probably could survive because arguably the class includes all of the possible plaintiffs.
So Jeff,
Yeah,
could
good.
I just ask to clarify? So that means if Trump, for example, issues an executive order that says something program is stopped, then a federal judge in one area, San Francisco or something, can issue his halt to that, but it only applies to the people right in that area or to those parties involved. It's not, doesn't apply nationwide anymore like it used to.
Right.
So
Is-
one federal judge
One
cannot-
federal judge cannot
stop it.
universally stop a action beyond the scope of the litigation before him.
Yeah,
So the scope of the litigation before him would include those parties and not other parties who have yet sought relief.
so the president's action
Could move forward on those other, against other people.
until it goes to the Supreme Court and they would rule on.
Yeah, then they might rule ultimately on the constitutionality of that. And a lot of injunctions are decided before even that judge has ruled on the constitutionality. It's a injunction is an equitable tool to preserve the status quo while the parties battle it out in court. And so basically you want to hold things fast, hold things in the status quo, so nothing changes, no one gets deported, or no executive order gets implemented until it's determined that that executive order is legal.
And Jeff, what do you think about that? Do you think that's fair that one federal judge should be able to stop a presidential order?
You know, you can understand both sides of it. It again, and it kind of comes down to, um, what the law says about the jurisdiction of the federal judges, and what their ability to make that kind of ruling is. And so I may think it's fair or unfair, but it may not, it may be okay. I mean, it may be proper to say, federal judge, you can't have unlimited power to issue a universal injunction.
Yeah.
You can only decide the case before you, and you can't decide the outcome of that executive order for people that aren't in front of you. And so that makes sense. And I don't necessarily disagree with that. And in some cases, it's going to be fair or more fair. And we could decide that federal judges could have that authority, but we would need to have that in the Constitution or a federal statute somewhere. And what the Supreme Court is saying that is that the current Constitution and the current federal law relating to federal court judge power, judicial power, does not include that power. And, you know, the practice had been for those kind of orders to be enforced. And so that gave the judicial branch a little more oomph, a little more power in its separation of powers. Now taking that away from federal courts, you know, weakens the judicial branch a little bit and takes away its ability to check the executive branch, for example. So that you could have the debate whether it's good or bad, and might conclude that it would be good for federal judges to have that power. But litigants need to do then something, you know, along the lines of the class action.
Sorry, is there a way to interpret that says that will increase state rights against versus like the federal? Or meaning that each state would have to bring up its own litigation? Maybe I'm stretching.
Well, I mean, in that terms, you really need a federal lawmaker to decide these federal questions on executive orders and things like state court wouldn't have the ability to have the final say on that. But to that point, though, I think what we do see as our Congress has been very weak for a long time, I think. And cases like Dobbs defers abortion issues back to states. So I think states are in a position to fill the vacuum left by some of these other actions. The inactivity of our federal Congress creates partial vacuum of power that's partially filled by the executive orders and that kind of action. It's also filled by states. State legislatures then can do things for their state in the absence of federal action that preempts it. So state courts, and particularly is, you know, you hear about a court or a state like California, which has very active legislative powers. You know, they have air emission quality controls. They have so many laws that go beyond what federal law does. And, you know, they do that because the Congress won't do anything more. And other states then do follow that from time to time. And Colorado has done its share of things like that too, I think. Coming back to birthright citizenship, and I guess I'd like to say one more thing and then ask anybody if they have any other questions about that, because that one seems kind of overreaching. And my opinion is that it will not survive the constitutional check. And there's a key case that was decided back in 1898, and it involved the Chinese Exclusion Act,
Wow.
where a young man who was born of non-US citizens, but of Chinese descent in the United States, went back to China and tried to come back, and they wouldn't let him in. And he got a lawyer, and they sued, and he was found to be a citizen under the 14th Amendment. even though his parents, were not citizens.
So
And
he
they
was
could,
born here?
he was born here. So he was claiming birthright citizenship under the 14th Amendment and he won. And so that's the earliest example of that, and it seems pretty clear cut. So in order to do what Trump wants to do, our Supreme Court would have to reverse that decision that's now 140 years old. So
But they
But
did
they could.
reverse Roe versus Wade.
well, that was only 40 years old. So, yeah, it's possible they could overrule that and all the other precedent, since then related to that. But it seems unlikely. Anybody else have any questions or thoughts about that one?
There was an article in the Denver
Unix.
Post this morning about a case where, birthright, the immigrant was declared a US citizen, but yet they're saying that maybe because he had committed illegal acts, they could say he's no longer a citizen. Did you see that?
I didn't see that, but that would probably implicate the US Naturalization Act.
There you go.
And that act sets forth all of the terms and conditions and things you have to go through to become a naturalized citizen. And I'm not sure that that's unreversible. You know, if
And
you,
that was what was talked about in the paper, so you might wanna.
yeah, that'd be an interesting thing.
How many people do we know that are naturalized citizens? And
Yeah, not that many. Question behind you?
Well, the point is that isn't there clear language in the Constitution regarding birthright citizenship? So apart from that decision, the Supreme Court would have to essentially reinterpret a very clear language in the Constitution that for anyone reading it would seem that anyone born in the United States is a US citizen.
Yeah, no, that's where we would start with. And that's some of the argument that would come out is, the language is in section 1 of the 14th Amendment, and I'll just read it right now. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Seems pretty clear. And at the time it was enacted, it was clearly intended to clear up any confusion about former slaves, that they were citizens of the United States. And from the case that I was just telling you about, it applies to non-former slaves. It applied to this young Chinese man. So it should apply to anybody. But if you go back to a textualist viewpoint and want to just look at the words at the time they were enacted, you'd use the most narrow definition possible. And you wouldn't think of the consequences or the purpose. I mean, think of the consequences alone, that we have 140 years of birthright citizenship. All of those people who are somehow retroactively made non-citizens seems pretty absurd, that even the most ardent textualist might be tempted to think about, well, let's consider the consequences and the history, and those things may outweigh and shift me from being a strict textualist to maybe just being mostly a textualist.
Jeff, aren't the Trump lawyers trying to attack that second aspect of the amendment subject to the jurisdiction thereof? Isn't that where their attack is taking place?
Yes, I think that is the loophole that they're trying to make as big as possible to drive as much of their argument through. That's really the only loophole in it. That's the only language that might be ambiguous. Now, that language has been litigated already as well, and it has been applied to mean people that are born in the United States of foreign diplomats and attachés that are here, that are technically not subject to US jurisdiction, but they're subject to the jurisdiction of their own country as a representative of their country. So if you're the ambassador and your spouse from Croatia and you have a child in DC at the embassy or at the hospital there, that kid would not be able to claim birthright citizenship. And so that's kind of what that language has been meant over time. And so they'd have to change that.
Can you imagine in a hospital religiously adhering to a medical manual that was written in 1775? And, you know, following it with such devotion, what did they mean by this? And it's, in the same sense, our Constitution has some incredibly archaic things that simply are gone with the wind and out of date so bad that they're almost laughable.
Yeah.
Yeah.
And to that point, you know, being an advocate of the traditional means of interpreting the Constitution, I would suggest another phrase that's been used, that it's sort of a living document or an evolving document, and that words shouldn't be tied or tethered back to just what it meant back then. For example, the word people, as it's used in the preamble. Even if that's kind of what the founders had in mind, that's not what any of us have in mind, and not what we have fought a civil war over and had just so much social strife and civil rights actions, and that clearly can't be. We can't go back in time on that. We've moved way beyond that, and person and people means everybody, and the ideals I think we had of equal protection and due process for everyone, we really mean everyone now.
No longer 3/5 of a person.
Yeah, no longer 3/5 of a person for, yeah,
Jim had a question in back, Jeff.
okay.
The jurisdiction thereof that also excludes members in native nationalities.
It excludes them.
Indigenous.
Okay,
And this is just kind of a restatement that I heard. That the,
Louder, Bill.
okay, the so-called founding fathers, no way could have imagined what we have now. And, so they, it's been said, had this view that the governance of the colonies or the whatever came from that would be basically landed barons, white men that had land, and they would be very reasonable and argue with each other, and that was the way of putting it in. That's who is gonna be running the government, and it's a good illustration of, they could not have imagined.
right.
Yeah.
And yeah, and to elaborate on that, they imagined too that there was so much land and it was pretty easy for a white male to get land and to become a well-off or a middle class, kind of to be in that group. And there was not the income or wealth inequality that we have now. They kind of thought it was very egalitarian for that time, that this broad swath of people were all going to participate in the government. So it was kind of very, very advanced thinking, even though it looks archaic now to us. They were thinking of something that included a very big spectrum of people that were able to fit in that category and participate in the governance of things. They didn't, and not only did they not imagine the big cities with working class people and whatnot, they probably did not imagine the wealth inequality that we have now going on, and it seems to be getting worse and worse, so. Other questions? We're getting close to the time, so.
We've got about 18 minutes left.
Well, I didn't even get to immunity,
Let's do it.
which someone asked me about. I was asking people what topics they would like to hear about. But, I'll just touch on immunity. That was a decision from July 1st of 2024. And we were all kind of surprised by it. I think even Richard Nixon rolled over in his grave and said, where was that when I needed it? And,
What did it really say, Jeff?
so it says pretty much what you probably think and what the news reported it as. The founders envisioned a very energetic executive that needed to have a high degree of autonomy and not questioned in their activities. And so it ruled pretty straight up that the president has absolute immunity in all of their official government actions. And it talked about official government actions in different spheres. There's conclusive and preclusive actions, which are kind of in the Constitution or in the law. And then there's another sphere of kind of additional official power that is subject to a presumptive immunity. So everything basically that doesn't amount to a clearly unofficial act, and we don't know what that is yet. Everything else is either absolutely immune or presumptively immune. And so kind of the takeaways I say for this is really that impeachment is kind of our only remedy, and maybe non-reelection. So if you don't like the president, don't reelect them. Or if you have a Congress that would be willing to stand up to them, you could impeach them. And so one thing you should note, those are both political processes, not criminal processes. And the court distinguished that we shouldn't be criminally prosecuting a president for the things they did. Another takeaway from that case is, again, the amount of deference the court wants to give to the executive. And that's kind of been playing out in some of these other decisions. But so it's been pretty much kind of what it sounds like. President's immune as long as he's engaged in his official activities, even if it relates to an insurrection.
So it all came from that call to the Georgia Secretary of State.
Yep. Yeah, and those tweets to his followers.
Now, that was what you just described was the wording of the Supreme Court. And I don't have a constitution with me, but in the Article 2, isn't there, I'd like you to read maybe the clause that talks about what the responsibilities of the president is and what his liability would be, because it seems like there's some indication that he would be liable if he's going to be impeached. He's going to be impeached for something. So you read that article, that portion there?
Well, you've got multiple parts of what you just said. I mean, the executive powers are very broadly written. And then there's myriads of congressional statutes that give the executive and the executive branch powers they're just too innumerable. So it's very, very broad. And if you're going to have a robust or energetic, as I think the word they used, energetic executive, there's just tons of things that applies to. Now, the power of impeachment is for high crimes and misdemeanors.
And that's part of the emolument clause too.
Yeah, I think that's in Article 1. But in any event, impeachment is not necessarily a prerequisite to a criminal trial, and it's not a kind of alternative. I mean, it is the option. So you can impeach them, but you can't imprison them.
What happened last time? They could be pension.
Jeff, the first impeachment was Andrew Johnson.
Louder so people can hear.
The first impeachment was Andrew Johnson, and I'm just wondering what he did that fell under that high crimes and misdemeanor
Yeah, I don't know.
designation.
We've had plenty of debates over that recently because of all the impeachments that have been filed recently for quite a number of presidents. But it was I think they want to impeach Trump over the call to Zelensky, where he used his office to try to bribe him or pressure him or blackmail him to investigate Biden,
Hunter Biden.
Hunter Biden, and,
But he did that as president, so it's covered by immunity.
and when that didn't really go anywhere.
We need, in the context of what Ron was getting at, the founding fathers, the lifespan was around 50 years of age. Not factor in the fact that, gerontocracy and some of the frailties of aging. Certainly that was utilized in the Biden, reelection issue. But, this was the question that the state constitutions factor in, even though it may appear to be ageism. In many ways, there is a certain safeguard, just like airplane pilots. To do have an age limit. We have examples of Feinstein, Ginsburg, some are even the majority leader, McConnell. There's no protections for the American public on that aspect of frailty, not high crimes and misdemeanors, but just inability to function cognitively with the serious issues facing the American public.
There is a provision in the Constitution where the president becomes impaired enough that they can be removed.
25th.
25th.
Yeah, and I haven't looked at that in a long time, so I don't remember the details. You said it's the
25th.
25th?
But that's where the cabinet and others have to come to a consensus and say, we all agree and invoke the 25th Amendment. And you're not gonna get that by cabinet supporters who are yes people.
Right.
Correct.
Sycophants.
Yeah, so
Stand by, searching.
Well, also Wilson was said to be in his last year and a half, pretty incapacitated, but his wife.
Why,
Wife, which was a fairly recent wife, I believe, protected his image or shielded his actions.
and all the stories coming out now about Biden and how his staff protected him and
They're all taking the fifth.
kept it. And they're all taking the Fifth Amendment too before Congress. Yeah.
But, it was, from what I understand, it was fairly successful, Wilson, in terms of, a number of people knew it, but it never became
Yeah.
big enough for.
After his stroke.
Interesting.
and in this day of media where the president's on television almost every day, it's kind of hard to hide what their condition is
Yeah.
compared to the days of Wilson.
Yeah, the TV cameras are zooming in on his hands now. Now he's got makeup on his hands and his feet swollen and
But his ankles were
all
swollen.
his ankles swollen,
Yeah. He's got that Venus problem.
Yeah,
Venus valve.
Jeff, does it ever amaze you that America works as well as it does, considering all the problems and the unclarity of the language in the Constitution? And do you think we do a pretty good job of staying together despite all these problems?
I mean, history shows that we haven't always even done that. I mean, we had a civil war,
Yeah,
which is a lot worse than
yeah.
anything that we're facing right now. But, I think we still have a lot to be grateful for. I think our Constitution is still a wonderful governance document and a model that we should try to implement and keep it as strong. I think we should be very happy that we have 3 branches of government and we have a judicial system that allows our countries still to function. And we're pretty overburdened with bureaucracy and laws and whatnot, but yeah, we're still the envy of the rest of the world, I'd say.
In reference to what you were saying, I remember when Harvey Marx was here several years ago. The founding fathers did have a profound appreciation and understanding of human nature and the need for checks and balances. Checks and balances.
They knew we can't trust each other. And, but I think, you know, in knowing that and saying it, there's a certain,
Absolute power corrupts absolutely.
right.
And I remember Harvey making quite a point on there. They did have a profound insight on how human nature can deceive itself and that there needed to be protection. But in that sense, that's helped us survive as a.
I agree, and just our admitting that we understand that power does corrupt gives us sort of a freedom to be able to say, that we're not going to allow this power to collect too much in one place and recognize human frailty for what it is.
Yeah.
Well, I just agree with what you're saying, that we really, it really is pretty incredible. We have done incredible things with it, and I always look back to, I don't know, the Constitution, but I'm up in Benjamin, right there for, but Benjamin Franklin came out and they said, what do we have? And he said, a republic, if you can keep it.
Exactly.
And I think it was, we really, this is our best, we really think this is the way it should be done. And, but acknowledging, there's gonna be a hell of a lot of fighting about it.
Well, and it started with Washington stepping down. 90% of the revolution.
Oh, yeah, they went into.
90% of the revolutions in Central and South America end up with one dictator replacing the other.
Yeah.
Even the French Revolution, they only had a republic for 10 years before 1799, Bonaparte became the dictator.
Well, that's a hallmark of our country, is been the peaceful transfer of power after every election. And that's a tradition that I think we all respect and take great comfort in, that no matter, even if the other guys won and they're gonna get their way for a while, or you know, you're getting your way for a while, how, you know, however you view about that, you know that you get to go vote and it can go back the other way.
Come midterms.
I'm sorry, I have one more question about that, because I think Trump wants to stay in power. And, is there,
Yes,
something where he can extend his presidency?
no person shall be elected to the office of the president more than twice. And no person who has held the office of the president or acted as the president for more than two terms, 2 years of a term to which some other person was elected president, shall be elected to the office of president more than once. 22nd Amendment.
Yes, but is there a pathway he can take, to overturn that?
Well, he will argue that. I mean, and he'll figure out a path, but that one seems very clear. And then there's also some language in the, in Article 2 about the presidential term that reinforces that. So
It's not a clear path then.
it's as clear as it gets. I mean,
One of the-
nothing is ever certain.
One of the funny chants, Rachel, that I heard was Trump supporters saying they would run a surrogate person for president, like Trump's wife. And then upon election, she would resign and appoint him as president. Sorry, go ahead.
Yeah, yeah. They have Donald Jr. or Melania or somebody else that was totally malleable.
And then that would go to the Supreme Court and challenged, and they would have to decide if that was legal. So, but those are the things being talked about.
Yeah. In Georgia, I believe, in the sixties, Lurleen Wallace ran as in place of her,
George Wallace.
George Wallace, yeah.
Oh,
And everybody knew that he couldn't serve the term, but she was just a,
You could tell what to
It
do.
would be have to be kind of a convoluted process. Again, the 25th Amendment says that when there's a vacancy in the presidency, the vice president shall take office. So I suppose what you could, and then the president shall nominate a vice president. So you could have the president nominate a new vice president being Trump, and then have the vice president that's now the president resign, and that vice president Trump becomes the president.
There's always AI.
Yeah. Well, AI might be better.
Opinion, because of Roosevelt.
Do you think the American people can be
What
pushed
got put in.
before there's some major civil, disobedience and going against Trump in a very serious way. How, just your opinion, how?
Well,
far
I
you
think that's the kind of thing where the American people would push back every way they could, is if they try to circumvent every structure of the Constitution, every constitutional institution we have, and just act like a dictator. That's, I mean, and a lot of people would probably rise up short of something like that, but I would hope that we wouldn't sit around and stand for someone that would just say, I don't care what the 22nd Amendment says, I'm staying on as president.
We got that.
Yeah, well, we got a couple of years to see how that's gonna play out.
Midterms.
Day-to-day stuff.
Yeah, I mean, yeah, there's a lot that has to happen for him to be in a position. I mean, he may not even be alive then, but based on the last term, you know, and I have mixed feelings about some of the things that Trump's done. I mean, not everything he's done is as awful as it maybe sounded like, and some things have turned out way better than I imagined. But,
Like bombing.
well, a lot of presidents have bombed places, and, the circumvention of this peaceful transition of power that we were talking about before by violating the Constitution would be a deal breaker for me. And I would hope for everybody else.
It almost happens. Big rise up. Okay.
We just got a few minutes left. Jeff, you want to just take more questions?
Sure, we can take more questions if there are a few, or comments or observations. Ideas for part 3, we got a pretty good one.
Sure, go ahead.
If you're willing to do it.
And this is not regarding the president getting reelected, but there are a lot of things happening in the states as far as redrawing district lines and adding more legislative districts, like in Texas, that I read that they're looking at adding four or five, I can't remember the number, districts, you know, five districts. There's a lot that can be done underneath, you know, to keep the legislature, to keep Congress the way, it, you know, unchangeable by Democrats right now. I mean, it's so frozen. But, you know, there's a lot they're working on to keep that permanent. Make it keep it Republican, keep it pro-Trump. So,
Everybody should be involved, one party or the other, you should be involved, as your conscience leads you to make sure that, you know, the government stays fair.
We need to vote in the primaries.
Vote in the primaries, be active, read the papers, support, journalists. We're coming at a time too, where information is harder to get and harder to, so, you know, having more and more outlets that are trustworthy is important, because if we can't stay informed and know what's going on,
PBS.
we're done.
Get away with that too, trying.
Yeah, interesting that the
PBS.
PBS and NPR funds have been stopped now, so see if they
And that in
survive that.
Yeah, that in and of itself, you know, you can debate all day long what the role of the government is. What should it be doing? Should it have broadcasting companies? Should it be subsidizing farmers? Should it be researching this or that science? You know, that's been debated since the beginning of time, since the beginning of our country. But when you have something valuable like an information source like PBS, it's up to us. We're the consumers of that thing. We should donate. Make up the difference if it's important.
Good point.
Well,
Okay, we're
90% of the funding is local, isn't it?
Right.
Yeah, it's vast majority is,
That's the thing they keep forgetting.
Even my dog.
well, they want us to
Right.
bang
Right.
their gong for that.
we are out of time. Thank you, Jeff, for a good hour of discussion.
Thank you.
Appreciate it. Next week, Ron Puning is going to talk about China versus the US.
Ooh.
The Chinese
That's a USA.
USA. Thanks, everybody. Bye-bye.
Thank you, bye.